You can bring in the juries. Everyone can be seated. Members of the jury, I hope you had a restful lunch break. We are going to continue at this point with the defense's case. Please call your next witness.
Before we call our next witness, we laid the foundation through Luis Rivera for Defense Exhibit 50. At this point in time, we'd like to introduce that into evidence.
Any objection from the state?
No, Your Honor.
Defense 50 is admitted.
Thank you. At this point in time, the defense would call Marisel Scalzo.
Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may be seated.
Thank you.
You may inquire.
Thank you, Your Honor. Good afternoon, ma'am. Can you please introduce yourself and spell your last name for the jury?
Marisel Scalzo. My last name is spelled Descalzo.
And Mr. Scalzo, can you tell us how you're employed?
I'm an attorney,
Okay, what type of attorney?
a criminal defense attorney,
And how long have you been practicing?
since 2003.
During a period of time ending shortly after her arrest, did you represent Donna Adelson?
Yes, I represented her sometime in 2022 through maybe 3 months after she was arrested.
Okay. And I want to direct your attention specific to the late October and beginning of November of 2023. During that time period, was her son on trial?
I'm not sure about the dates, but it sounds about right.
Okay. During that time period, when her son was on trial and shortly after, did you have some concerns based on statements that she was making?
Concerns about Mrs. Adelson's mental state, yes.
Yeah. Can you tell us what those were?
She had made numerous statements about terminating her life if her son, Charlie Adelson, was convicted.
Did that cause you to take any steps or actions to determine what you needed to do?
Yes.
And what were those?
Well, first, I conferred with Daniel Rashbaum, who represented Charlie Adelson. So we discussed it, and we decided that we needed to call Ethics Council and call the Florida Bar to determine if we needed to take any additional steps, such as Baker acting her, or Baker acting as putting her in a mental institution, or anything else.
Okay. After doing that, did you have further discussions with Mrs. Adelson about her mental state and what she was going to do to try to clear things up?
Mr. Rashbaum and I spoke to her further, and, you know, she told us that what she really wanted to do was she wanted, to to get away on a vacation with her husband. Her husband agreed that this would be good for her mental state, and so we discussed a potential vacation.
Okay. At that point in time, was there anything preventing Mrs. Adelson from traveling?
As far as Mr. Rashbaum and I knew, there was not.
Okay. And specifically, there were no warrants for her arrest?
My understanding from speaking to Mr. Rashbaum, that Mr. Rashbaum had communicated with law enforcement and that there was no outstanding warrant. I had been in touch with the prosecutor of this case, and I apologize because I only remember your first name, but with Georgia. And we had discussed previously, not around this time, we had previously discussed that I represented Mrs. Adelson, so I assumed that if anything would happen, that if there was a warrant or if Ms. Adelson was going to be arrested, that I would be contacted.
Did you advise Mrs. Adelson that if a warrant was issued, that you would provide her with that information so that she could self-surrender?
So the discussions I had with Mrs. Adelson weren't exactly like that. Mrs. Adelson discussed what would happen if there was an arrest warrant, and the potential things that might happen. The prosecutor had never guaranteed for me that Mrs. Adelson could self-surrender.
Okay. Did you tell her did you tell Mrs. Adelson that self-surrender was something that could happen?
Yes, I did.
Okay. And on November 6th, her son was convicted. Did you speak with her after that, specific as to her ability to travel?
I don't remember the dates, but there was discussions about her traveling after the conviction, because around that time was when she was making the serious threat, was when Mrs. Adelson was making these serious threats about her life.
Just a moment, Your Honor. Nothing further, Your Honor?
Cross-examination.
Yes, sir. Good afternoon.
Good afternoon.
Now, if someone has a warrant, is it up to the defendant or the suspect, the person who has the warrant, to dictate their terms of surrender?
I don't think so. It's up to the law enforcement.
It's usually up to law enforcement to decide how or where to apprehend that person, right?
Yes.
But, so it's not a requirement of law enforcement to notify someone when they have a warrant, but that is sometimes a courtesy that's extended. Is that right?
That's correct.
And that is a courtesy that's sometimes extended in situations where, let's say, someone is not a flight risk, right?
It's in all sorts of situations you can have self-surrender extended to. I wouldn't limit it to only people that are not a flight risk.
Okay, would that be one situation?
I would assume so, yes.
Okay. And you were told that by Georgia, by Ms. Kappelman, that you wanted to know whether she had a warrant, she could turn herself in. That was some amount of years ago?
It was definitely before Charlie Adelson was convicted. It was on a phone call that I had. I offered it, and as I stated, Georgia Kappelman did not guarantee that.
Okay. But that was before Charlie's trial or verdict?
Correct.
Okay. After the verdict, or I guess during the trial or after the verdict, did you disclose to anyone in the state attorney's office that Ms. Adelson was suicidal?
Of course I didn't.
Okay.
No, I had an attorney-client privilege relationship with her, and I don't think that would have been appropriate.
Sure. And why was she suicidal?
Because her son had just been convicted, and she was worried he was going to spend the rest of his life in prison.
Was she also worried about getting convicted herself?
I don't believe that was even crossed her mind. She was only worried about her son.
Okay. Are you aware of a text message where she said that she was afraid she was next, but don't worry, she would take care of that?
I'm not. I'm sorry. Was that a text message to me, or?
I don't believe so.
Yeah, I don't have any knowledge of that.
Okay. At the time of, were you present when Dan Rashbaum told her that she may make it to the airport in time, or she may get to the airport and not be able to make it out?
Mr. Rashbaum and I don't believe that that was a telephone call. I don't believe that was in person. And I was on a call, and I myself also told Mrs. Adelson that we did not know whether there was, that we understood there wasn't a warrant, but that didn't mean she couldn't get arrested at the airport.
Okay. When you suggested, I guess, was the suggestion that you said that she take a vacation?
I don't believe I suggested it. I believe that that's something that was being discussed between Mrs. Adelson and her husband as something that would help her with her mental state.
Okay. So that's something they suggested, but not you?
Correct. I did not suggest that they take a vacation.
Okay. Did you know at the time that the vacation that they were suggesting, they were considering Vietnam, China, or Korea?
I did not know the location of where they were going.
Okay.
And it was never discussed with me.
So at that time, you didn't have knowledge that they were specifically looking for non-extradition countries?
I did not know one way or another where they would vacation to.
If Donna Adelson was overheard by law enforcement debating between either committing suicide or fleeing to a non-extradition country, do you think that would change law enforcement's stance that she could turn herself in?
Objection, Your Honor, calls for speculation.
Overruled. The witness has opined on this matter.
I'm not law enforcement, so I'm not sure. And I've never been in law enforcement, so I'm not sure.
I can rephrase it. Would you expect that to change the stance?
If I was law enforcement and I heard a target of investigation discussing a flight.
As her attorney,
Okay.
would you expect if she's overheard debating either committing suicide or fleeing to a non-extradition country that she wouldn't be expected to be able to just turn herself in on a warrant again after that?
I don't know. I think it would take, to be honest with you, I'm a criminal defense attorney, so it would be case by case. Probably that would make the bond hearing a little bit more difficult if those conversations were overheard. But every prosecution is different, and maybe the prosecutor would agree. I don't know.
Okay, 1 second. Specifically, though, about self-surrender, would you expect that to change law enforcement's stance as to self-surrender, not as to a bond?
Again, I think that that's specific to each case, and I don't know exactly what was overheard, so I apologize, but I don't really have a concrete answer for you, other than what I said before, that it would come up at a bond hearing.
Thank you.
Redirect examination.
Thank you, Your Honor. Mr. Scalzo, prosecutor asked you about fleeing the jurisdiction. My client talked to you about a vacation, correct?
That is correct. It was not fleeing the jurisdiction.
And the state also asked you about fleeing or going to a non-extradition country. Have you, in your career, dealt with extradition from foreign countries?
Yes, I have.
Okay. And merely because someone is in a non-extradition country, does that prevent the United States from attempting to seek their return or their extradition to the United States?
It absolutely does not, especially if you're a U.S. citizen.
Nothing further.
You may step down. Is this witness going to be recalled for any purpose?
No, Your Honor. I believe she might be able to get the early flight this evening.
You are released. Please call your next witness.
Just a moment, Your Honor. Defense would call Sarah Newhouse.
Please come up to the witness stand. Raise your right hand now. Do you swear or affirm the testimony you're about to give will be the truth?
Yes, sir.
You can take your seat. Please speak loudly and clearly. You may examine.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Can you please introduce yourself to the jury?
Yes, my name is Sarah Newhouse, and I am currently the Behavioral Wellness Coordinator for the Police Department. Back in 2014, I was the victim advocate.
You're a victim advocate for the Tallahassee Police Department?
Yes, sir.
Okay. And in your role as a victim advocate, what does that entail when you work for the police department?
Typically, it's following up with victims that are victims of crime, usually persons crimes, homicides, suicides, sexual batteries, domestic violence, things of that nature. And it's providing support, kind of being a middle person between them and the police investigation team.
And in that role as a victim advocate, were you working on July 18th of 2014?
Yes, I was.
Okay. Did you have occasion to get assigned to be the victim advocate for Wendy Adelson?
Yes, I did.
And were you present for the vast majority of her interview with law enforcement?
I was.
Were you also present when Wendy Adelson called her mother, Donna Adelson, towards the end of that interview?
I was.
And did you have an opportunity to listen to the portion of the interview where Wendy Adelson called her mother?
I did.
And I'm going to show you what is marked for identification purposes as Defense 71. Did you have an opportunity to listen to this exhibit?
I did.
Okay, and is the portion of the recording true and accurate reflection of what you remember from July 18th of 2014 when Wendy Adelson called her mother?
It is.
Okay. When Wendy Adelson called her mother, do you recall Donna Adelson's reaction to being told that Dan Markel had been shot?
Yes.
Okay. Did this upset her?
She sounded shocked, I guess would be the word that you'd say.
And it appeared that this was the first time she was hearing about it?
Yes.
And did she make any statements that you could hear from where you were sitting?
I don't recall if I could hear other than reviewing the video, but it sounded like a normal amount of upset given a crisis situation.
Your Honor, at this point in time, I'd move into evidence Defense 71.
Any objection?
Judge, I haven't reviewed this exact item, but based on what the defense has represented to me is on there, I don't have an objection. I do want to review it on the break and reserve the right to object. So subject to that, objection.
A lot of qualifications.
Well, there's just,
Members of the jury, we're going to take a brief break. The bailiff will take it to the jury room. You can be seated. If anyone needs to stretch their legs or use the restroom, please do it now.
is the witness telling Ms. Adelson she did an awesome job on the call after the call disconnects. So I would object to those two comments. I'm fine. I understand they don't tend to publish it right now, so subject to those objections, no objection to the exhibit once those things are removed.
Mr.
And-
Zelman?
As I indicated to Ms. Dugan when Ms. Kaplan was watching it, I got to remember how I snipped it, but I don't have a problem removing the comment before and the comment after before it's published for the jury.
That defense 71 will be admitted. The proper redactions will need to be made. You can bring back in the jurors.
All right, jury, you're in the courtroom.
Everyone can be seated. Defense 71 is admitted at this time. You may continue with your examination.
I have no further questions for this witness, Your Honor.
Cross-examination.
Did you hear any weeping or wailing going on at the other end of the phone during this phone call?
Not that I recall, no.
Did you know Donna Adelson?
No.
Have you ever met her?
No.
So you don't know what her normal demeanor is like?
Correct, I don't.
Okay. But Wendy Adelson, her daughter, presumably does know.
Correct.
And do you remember Wendy Adelson making the comment after that phone call that she handled that well?
Objection, Your Honor. That's hearsay. That's exactly what was asked to be removed from the recording.
Please sit down. As to the hearsay, sustain.
No further questions.
Redirect.
No, Your Honor. We'll just strike the question from Ms. Kaplan.
Members of the jury, you are to disregard. The last question of the prosecutor is to be struck from the record. You may step down. Will the witness be recalled?
No, Your Honor.
As to your exhibit, do you wish to publish or just leave in evidence?
Not at this time, Your Honor. I do need to make the edits that were requested outside the presence of the jury so that it removes the two references. That could just take a few minutes.
Well, the jury will have a brief break. The bailiff will take you to the jury room once again. Everyone can be seated. Please make all necessary redactions and changes at this time. other witnesses for the defense, it is time for the decision to be made.
I can tell the court that co-counsel and my client are deep in conversation concerning
I
this.
am capable of seeing that, Mr. Zelman. No narration is needed. Mrs. Kappelman wants the defense rest. Is the state intending to place or put on any rebuttal case?
I think not. If they rest without calling any further witnesses, that could change if Mrs. Adelson decides to testify.
Very well. At this point, I do need a decision. Mrs. Adelson, please rise. You've been placed under oath earlier this afternoon. Mrs. Adelson, I will advise you concerning your rights. You understand that you have the right to remain silent, and the jury will be instructed that your silence cannot be held against you in determining the merits of this case. Do you understand this?
I do understand.
Do you also understand that you have the right to testify as a witness in your case in chief on your own behalf?
Yes, Your Honor, I understand.
You understand if you do choose to take the witness stand, you will be cross-examined by one of the prosecutors.
Yes, I'm aware of it.
You understand that your credibility will be placed before the jury like any other witness.
Yes, Your Honor, I understand.
Have you been able to discuss with your attorneys the two rights that the court has placed before you?
Yes, we've discussed the rights.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not. I cannot make you testify. Your attorneys cannot make you testify. But ultimately, you must choose whether you will testify or not.
I don't have to choose. I was hoping I would have some time to speak to my attorneys.
This has already been discussed, ma'am. What is your choice?
Judge, since I was handling the prior witnesses while Ms. Fulford was speaking with Ms. Adelson, can I have a few minutes, please?
What exactly are we going to accomplish that we have not been able to since the trial started, pre-trial, the long recess yesterday, or even the lunch break today?
That's what I'm trying to determine, Your Honor.
I will give you exactly 5 additional minutes. From there, Mrs. Adelson has to make a decision whether she will testify or whether she will not.
Thank you, Your Honor.
If anyone in the gallery needs to use the restroom or stretch your legs, this is your opportunity at this point. One can be seated. Mrs. Zellman, Ms. Fulford, Mrs. Adelson, the extra time that you have been provided, that has come to a conclusion. We are not finished with the colloquy quite yet. I am not talking for the sake of talking. Before we have to move into any contempt, we do need to move on. Mrs. Adelson, the question remains, as it relates to your right to remain silent and your right to testify. What is your decision concerning these two rights?
At this time, I don't want to testify.
Very well. As I've previously stated, the jurors will be instructed that your silence cannot be held against you in any way. We will bring the jurors back out. The defense will rest its case on the record. Ms. Kappelman, you indicated the state will not have rebuttal.
Did say that, Judge. May I have a moment to confer with co-counsel?
Go ahead.
There is one matter, Judge, that I thought we might be able to reach an agreement on, and we have. I will need to prepare a written stipulation for Your Honor to read to the jurors. Or we can decide the language now if you find that more acceptable. It's a one-liner. The parties have stipulated or agreed that Patricia Bird was never listed on the defense witness lists.
As to that, prepare the stipulation in writing. It needs to be signed by counsel for all parties and the defendant. From there, the stipulation will be read prior to the court going into further instructions. The preliminary copy of the jury instructions was sent to everyone this afternoon. Did everyone receive it?
We received it, Your Honor. We have not yet had a chance to look through it.
All right. We'll bring the jurors back into the room. The defense will rest. We will send them home for the evening. We'll give you a few minutes to look through the instructions. We'll go through the charge conference. And then tomorrow we will move into instructions and closings.
Your Honor, can counsel have a moment to confer concerning whether or not we are going to rest at this point?
Do you have another witness to call?
That's what we need to discuss, Your Honor.
We've done a lot of conferring. Please quickly come to a decision as to whether there is another witness, in fact, for the defense. Is there another witness to be called?
Your Honor, we are going to be tendering 2 exhibits to the court to introduce. I believe that both qualify under hearsay exceptions. The state's indicated that that they're objecting. If I could just have a moment.
Mr. Zellman, concerning the items, we do need to move on so a ruling can be made.
Your Honor, yesterday the state, or I'm sorry, not yesterday, but earlier in the case, the state introduced excerpts of the 2014 calendar that belonged to my client, as well as the 2023 calendar for my client. Under the rule of completeness, we are asking that the court admit the complete 2014 calendar, as well as the 2023 calendar that is I believe it's States 51. No.
What's the question?
Cattleman, concerning these items, what is the state's argument?
State's objection is hearsay, Your Honor. The portions that were admitted by the state were for very specific purposes. The rest of this item is not needed to add context to those individual entries. It's a day calendar, it's not a narrative. I don't think there's any argument for completeness. There's tons of self-serving hearsay in those documents, and the state objects.
Your Honor, with respect to the 2023 calendar, the state introduced a few pages that listed my client identifying items that she was going to sell. Based on the questions that were asked, the implication from that is that my client was selling these in anticipation of fleeing the country. Contrary to that, there are a ton of pages going back to January 9th of 2023 where my client lists those very same items to get prices to sell, to sell, to sell. So it is misleading to just put in those couple of pages that the state put in on the 2023 calendar for purposes
Who was
of...
going to lay the foundation concerning the item that you wish to admit?
Foundation's already been laid by the state, Your Honor. It was seized
I
by...
believe as the inculpatory matters, yes. As to whether or not she was planning to sell something in January of 2023, what witness testified concerning that?
Judge, the implication from the state's admitting those pages is that my client was selling these in anticipation of fleeing. Under the rule of completeness, we should be entitled to introduce the additional entries from the calendar showing that it didn't just start around the time that she decided to travel to Vietnam, but it happened previously. Not for the truth of the matter asserted, not that she was...
Hold on. These are not recordings. A book with several entries is somewhat different from a recording. As it relates to recordings, the rule of completeness, I believe, serves a different purpose in the manner that you're describing. As to each page of this planner, all of the information is not inculpatory. So to that end, what witness has laid a foundation for the pages that you seek to admit that are separate from the inculpatory information?
All we're seeking to admit are the pages from the 2023 calendar that list those additional items. List the items that the state has already put into evidence as my client intending to sell them prior to leaving the country. I've printed out the specific pages and I prepared a copy with highlights to be able to present to the jury during closing. But it's not the entire, we don't have the entire 2023 calendar. It's been marked for identification and it's in the clerk's possession. So these are just the pages with those entries.
As to that, I will reserve whether the rule of completeness will drag across the pages that you're seeking to admit. I'll do some additional research, but again, every item that appears in the calendars does not have a relevant or probative hook to this matter. If there is not a witness that will testify or lay a foundation concerning this, I will reserve for now. Depending on the court's ruling, you may argue it in closing. It's the same argument as the 2014 calendar.
Just a moment. Excuse me, Your Honor. The argument for the 2014 calendar would be the same under the rule of completeness. Obviously, there are things in here, and I said this to Ms. Kaplan earlier, that include personal information that would have to be redacted. Prior counsel provided a scanned copy of this to the state. If they could send that to me, I could identify the items that I think should be redacted. The specific purpose of offering the 2014 materials has to do with planning the 70th birthday party of our client's husband and the specific entries that she made identifying the tasks that she was going to carry out for that.
Again, is there any witness who will testify to these matters, or you're just offering them as rule of completeness?
Rule of completeness, Your Honor.
Ms. Kappelman, any additional argument that you might already made?
The only entry from the 14 planner that was admitted, has been admitted so far in this trial is the page that shows
The license plate
the
number.
license plate number, sir. And so I don't see how birthday party planning adds to the completeness of possessing the license plate numbers. I would object. In addition, I think this exhibit is in a little bit different posture because the 2014 planner in its entirety has not been identified at all. Only that page was identified. The 23 planner was identified as by a witness as being seized from the residence.
I will reserve ruling as the 2014 planner as well. Beyond that, if the court does permit these items to be admitted, the defense will be able to admit them prior to any instructions and closings, and you'll be able to argue them if they are admitted.
Yes, Your Honor. And for record, what I've done is I've marked the 2013 excerpts as defense, the 2023, sorry, as defense 51, and the 2014 as 76.
Please leave them with the clerk.
Judge, if Your Honor does rule that those items are admissible, the state would request complete redactions of all the items that are not related to the specific purposes the defense articulated.
Certainly no objection to that, Your Honor.
Please bring in the jurors.
And Judge, the state has made I want to check the redactions on this video.
I believe this is just being admitted without being published, correct?
That's correct,
Yep.
Thank you.
Jurors are fine to come in.
All right, you're entering the courtroom.
Everyone can be seated. Defense may call its next witness.
Your Honor, at this point in time, the defense rests.
Members of the jury, with the defense having rested, is the state planning to recall or call any rebuttal witnesses?
No, Your Honor.
With both the state and defense having rested their cases at this time, we are going to go into recess for the evening. I have some matters that I need to discuss with the parties, and from there tomorrow you will receive your instruction on the law and the closing arguments will take place. Once again, do not discuss this case with each other or any other person. Do not seek out any additional or outside information from what has been presented to you in this courtroom. Please report tomorrow at 8:45 and we will get started at 9 o'clock, or at least attempt to. Have a good evening. Everyone can be seated. Please open your copies of the jury instructions. My custom in going through the jury instructions is to go through each one. Any requests or changes that are being asked for by either party, we will address as we go through each instruction. Let's start with 3.1, Introduction to Final Instructions. Are there any requests or changes being sought?
No, Your Honor.
No, sir.
3.2, statement of the charge. Any requests or changes?
Not from site.
Your Honor, the only request that I would make is that the name of my client and the names of the charges do not be in all caps.
So stylistic changes.
Yes, Your Honor.
State, do you wish to be heard?
No, sir.
I will make that change. Let me make a note. Moving on to 7.1, introduction to homicide. This is a mandatory instruction in all murder cases. As to the first paragraph, Donna Adelson is accused of first-degree murder in count 1 of the indictment. Is there any request or change?
No, sir.
As to the next paragraph concerning lesser includeds, is the defense asking for all Category 1 lesser includeds?
Just confirming my recommendation being approved by our client, Your Honor. Your Honor, the defense would request the manslaughter lesser.
As to the second degree lesser, are you requesting that as well? It's Category 1.
With the although it's a Category 1 lesser, it still carries the same penalty. So we are not requesting second degree.
Is the state requesting second degree as a Category 1 lesser?
Yes, sir, we'd be. Yes, sir, we'd be requesting all lessers.
Well, all Category 1 lessers will be given. Second paragraph will read in the introduction, first-degree murder includes the lesser crimes of second-degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. I believe the indictment refers to the victim as Daniel Markel. Does either party have a preference?
To conform to the indictment, we would request his full name, Your Honor.
Acceptable, sir.
If you find Daniel Markel was killed by Donna Adelson, You will then consider the circumstances surrounding the killing and deciding if the killing was first-degree murder, second-degree murder, or manslaughter, or whether the killing was excusable or resulted from the justifiable use of deadly force. The definition of justifiable homicide and excusable homicide is either party seeking these. Not entirely certain we have any evidence in the record that would support giving them, but as either party requested.
Just a moment, Your Honor. I would agree with the court's conclusion there, Your Honor.
Mr. Evans, Ms. Koppelman,
No objection remaining.
the definitions of justifiable and excusable homicide will be removed. As to any other degrees, I believe the evidence remains the evidence. I do not find where there is a basis to give either set of instructions as to the lessers. Final paragraph of the introduction will read, I now instruct you on the circumstances that must be proved before Donna Adelson may be found guilty of first-degree murder or any lesser included crime. As to count one, the state is only proceeding on the premeditated theory. Is that correct?
Yes, sir.
Any reference to felony murder will be removed. The elements of first-degree premeditated murder. Element 1, Daniel Markel is dead. Element 2, the death was caused by the criminal act of Donna Adelson. Element 3, there was a premeditated killing of Daniel Markel.
Just the stylistic issues that we raised previously.
Very well. Instead of caps, they will be in upper lowercase. Moving on to the definitions. The definition of an act will be given. Killing with premeditation, that will be given. The question of premeditation, that will be given. The portion that will be omitted, give only if there's evidence the defendant acted in the heat of passion on legally adequate provocation. That will be removed. All right, instruction 3.4. This deals with the lessers. Is there any objection or request other than the stylistic issue previously raised?
Yes, sir.
Your Honor.
All right, 7.4, second-degree murder. Introduction to homicide will be given. This portion of the instruction will be removed. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. Element 1, Daniel Markel is dead. Element 2, the death was caused by the criminal act of Donna Adelson. Element 3, there was an unlawful killing of Daniel Markel by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. As to the definitions, I believe act is repeated. Is there any objection to this stating an act has been previously defined above?
I don't have a legal objection to that, Your Honor.
Mr. Evans?
No objection.
The second definition, an act is eminently dangerous to another and demonstrating a depraved mind, that must be given. In order to convict of second-degree murder, it's not necessary for the state to prove the defendant had an intent to cause death. That will be given. Give only if there's evidence the defendant acted in heat of passion on legally adequate provocation. That will be removed. The next lesser, 7.7, manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. Element 1, Daniel Markel is dead. As to element 2, which theory is the state proceeding on? Well, A and B will be split by an or. Donna Adelson intentionally committed an act or acts that caused the death of Daniel Markel, or Donna Adelson intentionally procured an act that caused the death of Daniel Markel. Right. Concerning the State versus Spencer italic, that will be removed.
And my understanding, Your Honor, is given the fact that the defense has not requested that instruction, has agreed there's no legal basis to give the instruction, there is a concession that the homicide of Daniel Markel was not excusable or justified.
Zellman, do you need to be heard concerning the concession that it's not excusable or justified?
Not in the facts of this case, Your Honor.
And does the defendant agree with that concession?
Very well. Mrs. Adelson, do you understand what is being omitted from the jury instructions?
Just 1 second, Judge.
Go ahead.
Okay, Judge.
Mrs. Adelson, do you understand what is being omitted concerning whether this homicide was justifiable or excusable?
I do.
As to that concession, do you need anything else that you need to discuss with your attorneys?
Yes. She said yes.
Please discuss it with them now.
Thank you.
Ms. Adelson, you understand the concession that is being made as to justifiable and excusable homicide.
I understand that, Judge.
You are giving your consent to this.
I am.
Let's move on at this point. The paragraph that states every person has a duty to act reasonably toward others if there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act. I believe the period needs to go there because there will not be any discussion of justifiable or excusable homicide. Does either party wish to be heard?
We concur, Your Honor.
In order to convict of manslaughter by act, that paragraph will be given. The last portion. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, and which caused death. The justifiable and excusable portion of the sentence would be removed. Does either party wish to be heard?
No.
No, Your Honor.
The definition of procure will be given, and all other references to culpable negligence will be removed. Moving on to 3.5 sub A, principles. The two elements are static. As to the portion below that is italicized, or any of the italicized portions being requested. I believe as to the first paragraph where it says attempted homicide cases,
We're not, no, Your Honor. Just for the completed offense.
say that one more time, Mr. Evans.
We're not asking for the attempt, we're just asking for the
Correct.
completed offenses.
I believe that instruction must be given for first-degree premeditated murder, and all references to attempts of any other sort will be removed. The state must prove the defendant intended that the killing of Daniel Markel occur. As to the paragraph that concerns second-degree murder, felony murder, or other attempts, I believe this paragraph needs to be given as it relates to the lesser as well. For second-degree murder, it is not necessary for the state to prove the defendant intended the death of Daniel Markel.
Your Honor, I think under that, the manslaughter instruction, or manslaughter needs to be included.
Concerning whether an intent was necessary for manslaughter as well, Mr. Evans.
You have to intend the act, but you don't have to intend to kill.
As to that inclusion within the principal instruction, does the defense wish to be heard?
Just a moment, Your Honor. Not sure that manslaughter is included in that, Your Honor.
It's not included in the standard instruction, no.
Can I have some time to research that to make sure that I'm not inviting error.
That's fine.
And Mrs. Dillon, you can contact me on that, Judge, and I'll let you know what the matter is seating.
Yeah.
Right. If given to the jury as requested by the state, it would essentially mirror what it states as the second-degree murder. For manslaughter, it is not necessary for the state to prove the defendant intended the death of Daniel Markel. All right. No weapon enhancement is being sought by the state. I believe that paragraph needs to be removed entirely. Does either party wish to be heard concerning those?
Are you asked?
For cases where the criminal statute includes a higher degree because of a firearm.
Yes, sir. I would skew down, move down the principles already connected to that. So I ask yes or no. There's no evidence that the defendant in this case actually possessed the firearm, so no, we're not requesting it.
It will be removed. .5 sub B, principles when active participant hired by defendant. If the defendant paid or promised to pay another person or persons to commit a crime, the defendant is a principal and must be treated as if she had done all things the person who was promised or received the money did if the state proved beyond a reasonable doubt. Then elements 1, 2, and 3 are to be given. As to the bracketed portion of element 3, the offense that the state is asking for to read in element 3, would this be first-degree murder?
I'm sorry, Your Honor. Can you say that again?
Element 3, the bracketed portion that says crime or attempt, the crime that the state is requesting, is that first-degree murder?
Yes, sir, but I don't believe that, I don't think it asserts crime. I think you just leave the crime was committed by another person.
So not a specific crime, just crime.
Yes, and I think that's why they have attempt.
Unless you want the offense to be named, I will leave it at crime.
I don't believe,
I'm going to look at
this
this.
crime is the appropriate one given the standard instruction.
I'm going to look at the standard briefly, Your Honor.
The other person that is referred to in the bracketed portion, or any specific names being sought, or just the other person?
Just the other person, Your Honor.
I would ask that the individuals, Sigfredo Garcia and Luis Rivera, be named.
I believe within the indictment, the named co-conspirators are Charles Adelson, Catherine McManawa, and or other persons.
For count 1, Your Honor, there's no one identified.
Mr. Evans.
You, for principal instruction,
3.5 sub B, element 3.
yes, sir, but I'm saying for principal instruction, you do not have to allege it in the indictment in order to be entitled to principal instruction.
Well, it will read the crime was committed by the other person. As to the persons who committed the crime, I believe the evidence in the record is clear. It can only be argued that Luis Rivera and Sigfredo Garcia were the actual trigger men, although who may have put them up to the act as a conspiracy, that is for the jury to determine. Any other matters that need to be addressed with 3.5 sub B?
Just doing away with the firearm part of it.
That will be omitted.
And Your Honor, there's something I wanted to address briefly on 3.5A.
Go ahead.
My reading, this is the new instruction.
This is the straight from the Florida Supreme Court on the Florida Bar website instruction.
Well, we are making the affirmative election to use the current instruction rather than the instruction that existed in 2014, which my client would be entitled to request.
This is the current instruction.
I'm sorry, yes.
This is the current instruction.
Yes, we are making the affirmative request for this rather than the old instruction. I wanted to make that clear for the record.
Moving on to count 2, conspiracy to commit murder. To prove the crime of criminal conspiracy, the state must prove the following 2 elements beyond a reasonable doubt. Element 1, the intent of Donna Adelson was that the offense of first-degree murder would be committed. Element 2, as to agreed, conspired, combined, or confederated, which are being requested by the state.
All four.
In order to carry out the intent, Donna Adelson agreed, conspired, combined, or confederated with Charles Adelson, Catherine McBanawa, and or other persons to cause the first-degree murder to be committed either by them or one of them or by some other person.
Your Honor, on that, I think I understand the way it is written, but in order to avoid confusion, because the and or would apply between the Charles Adelson and or Catherine McBanawa and or other persons. So I think it could be.
You're just requesting an and or between the names.
Yes.
Defense wish to be heard.
Your Honor, I always have a heartburn when I see and or in a jury instruction.
Going back to the indictment, these are the individuals that are within the charging document.
I understand that it's in the indictment. I think it leads to potential confusion with the jury. We would ask that and or not be included.
And if that's the case, then you could put simply or. So and or, my understanding of and or are, it can include, basically, if you put something or, I mean, this one, this one, or this one, or this one, or this one. And so in this case, if it's Charles Adelson or Catherine McBanawa or other persons, that would be acceptable to the state.
I don't have a legal objection.
Conjunction?
Yes.
What's your function?
Yeah.
Very well, Charles Adelson or Catherine McBanawa or other persons. It is not necessary that the agreement conspiracy, combination, or confederation to commit first-degree murder be expressed in any particular words or that words pass between the conspirators. Then lastly, it is not necessary that the defendant do any act in furtherance of the offense conspired. As to the affirmative defense, I am not aware of any evidence in the record that would require this to be given. Does the defense have any argument?
Legally, Your Honor, there's no evidence of it.
It will be omitted. Count 3, solicitation to commit murder. To prove the crime of criminal solicitation, the state must prove the following 2 elements beyond a reasonable doubt. Element 1, Donna Adelson solicited Charles Adelson, Catherine McBanois, and or other persons to commit first-degree murder. As to this, are the parties asking this to read with the same or that it does for conspiracy to commit?
Yes, sir.
Yes, Your Honor.
Very well. Element 1, Donna Adelson solicited Charles Adelson or Catherine McBanois or other persons to commit first-degree murder during the solicitation, and which are being requested by the state.
All 4, Your Honor.
During the solicitation, Donna Adelson commanded, encouraged, hired, or requested Charles Adelson or Catherine McBanois or other persons to engage in specific conduct which would constitute the commission of first-degree murder. It is not necessary that the defendant do any act in furtherance of the offense solicited. The crime of first-degree murder has been previously defined in these instructions. The definition of solicit must be given as well. The affirmative defense will be omitted based on lack of evidence.
Your Honor, I believe we're also entitled to a principal instruction on solicitation. I think the only area.
Go ahead.
I think the only area principle doesn't apply is for conspiracy.
Do you wish for me to move then the 2 principal instructions to the very end, and then they can be argued as to counts 1 and 3 is necessary?
You could put it there, or you could simply state the principal instruction applies to solicitation with murder as they have previously been defined. Or do we need to?
Defense?
We would object, Your Honor. How can one be a principal to solicitation? I'm not sure that that's correct. And as with the previous issue, I want an opportunity to look at that. That's not been requested in previous co-defendants trials, or at least it hasn't been given.
I think the easiest way to settle this would be to move the 2 instructions to the end of the counts, and then that way they can be argued as necessary for which counts they apply to.
The concern that the defense has, Your Honor, is whether or not it's legally appropriate. That's what I'd like the opportunity to address.
As far as that, you can research the matter whether it can be argued that someone is a principal and solicited.
Thank you.
For now, I will just move the 2 instructions to the end of the counts.
At the end of the counts, it just needs to be clearly stated that conspiracy, it does not apply to the conspiracy count. I think we're all in agreement on.
I can add it, but ultimately, no instruction can be argued as to a defense that it does not apply to. Does the defense wish for me to add at the end of the principal instructions that this does not apply to conspiracy?
Yes, Your Honor. And that might be a moot point depending on the research that I do later.
And then we'll just add at the bottom the principal theory. Or actually, this instruction does not apply to count 2. And I would do that for both principal instructions. Right, moving on to intent as a standalone instruction. This is not a standard instruction, but comes from standard jury instruction 13.1 burglary, which gives a definition of intent. This was given in the prior trial for Charles Adelson, and I have given it previously in murder cases. Is either party requesting it, or do you wish for it to be removed?
We're requesting it, Your Honor.
The intent instruction then will remain.
We would object, Your Honor.
What is the basis?
The basis is it's not a standard instruction.
100% speaks to the facts and evidence in this case as to how the jury must determine whether your client had intent. Over objection, it will be given. 3.7, plea of not guilty, reasonable doubt, and burden of proof. All standard language from the current instruction. Does either party wish to be heard?
No, sir.
No, Your Honor.
3.9, weighing the evidence. The opening paragraph will be given. As to the witness testimony, 1 through 5 will be given. As to the give as applicables, which are being requested.
I think probably number 10 is the only one we're not requesting. So 6, 7, 8, and 9.
Does the defense have any argument for the giving of number 10?
No, Your Honor, we agree.
Number 6, has the witness been offered or received any money, preferential treatment, or other benefit in order to get the witness to testify? Number 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Number 8, did the witness at some other time give a statement that is inconsistent with the testimony he or she gave in court? Number 9, has the witness been convicted of a felony? Or misdemeanor involving dishonesty? Whether the state has met its burden of proof, that will remain. To the next set of give as applicables, law enforcement witness, is this requested?
Yes, Your Honor.
No objection.
The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration. Expert witnesses. Experts are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. As to the issue that came up earlier with the testimony of Linda Bailey, is the state requesting any instruction to be given to the jury concerning that testimony?
Yes, Your Honor.
What is the requested instruction?
I have it typed out for you. Would you like to
Yes.
provide the copy to the defense? Sorry about the typo in the title and the certificate of service. It's all on Mr. Evans.
Right, as to the requested instruction, was the witness present in the courtroom during the testimony of another witness or other witnesses? Did the witness violate the court's order not to be present in the courtroom during the testimony of another witness or witnesses? What is the defense's position?
Just one. We don't have an objection to the first one, but the second one we do.
What is the objection? Is the second?
Your Honor, it's based, the witness's presence in the courtroom is based on our apparent misunderstanding of the discussion that we had at sidebar last week. As a result, we think that the first one is an accurate statement of law, but under the facts, the second one would be inappropriate.
Mr. Kappelman, what is your argument for the giving of the second?
I'm fine with just the first one, Judge.
Well, after the expert witness instruction, the next instruction will be, was the witness present in the courtroom during the testimony of another witness or witnesses? Accomplices and informants. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime has been promised immunity from prosecution, hopes to gain more favorable treatment in his or her own case. I believe we have number 3 of the bracketed portions. Are any others being sought?
Your Honor, it has just dawned on me where you're sticking the previous requested instruction about the witness was present in the courtroom during the testimony of another.
Yes.
That's probably better under weighing the evidence as opposed to, because
You're asking for this then to be inserted into the 10, or what would be the 9 questions and make it 10?
yes, because I don't know how much sense it would make if we read, like other witnesses, you may believe, disbelieve all or any expert testimony, and then was the witness present in the courtroom during the testimony of another witness or witnesses. Certainly it's hanging out there as to what does that mean?
I understand what you're getting at. Does the defense wish to be heard as to the position?
We don't have a legal objection, Your Honor.
Then it will be question 10. Let me move that now. All right. Going back to accomplices and informants, for example, a witness who hopes to gain more favorable treatment in his or his or her own case. Are there any arguments for claims to have helped the defendant has been promised immunity?
Not from the defense, Your Honor.
Those will be admitted. You must consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider, and I believe this would just be her testimony.
Yes, sir.
Your Honor, can we go back to the first bracketed language, please?
Which is being requested.
Claims to have helped the defendant commit a crime. I think that would apply to Ms. McManila and to Mr. Rivera.
State.
So, it's fine, Your Honor. So for the record, as I understand it, the bracketed languages under accomplices and informants,
Who claims to have helped the defendant commit a crime or hopes to gain more favorable treatment.
all right, yes, sir.
So while a witness of that kind may be entirely truthful when testifying, you should consider her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. There have been no children witnesses. The defendant has not testified. Witness talk to lawyer. Is either party requesting this?
Yes, Your Honor.
That will be given. And be given all cases, you may rely upon your own conclusion about the credibility of any witness. That will be given. Defendant not testifying. This will be given in full. And we'll just change the pronouns to all feminine. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. As to defendant's statements, I do not believe there was ever a statement given by the defendant to law enforcement. This specifically goes to whether the statement was freely and voluntarily made. As to that, as there is no law enforcement statement, this will be removed. Does any party wish to be heard concerning this?
No, sir.
No, Your Honor.
Rules for deliberation. Standard instruction, this will be given. Does either party wish to be heard?
No, sir.
No, Your Honor.
Cautionary instruction, does either party wish to be heard?
No, sir.
No, Your Honor.
Single defendant, multiple counts, does either party wish to be heard?
No, sir.
No objection.
3.12 verdict. Any objection or request?
No.
Moving on to the verdict form. Count 1, we the jury finds as follows. As to count 1 of the indictment, first-degree murder. Check only one letter choice as to this count. Option A, defendant is guilty of first-degree murder. Option B, defendant is guilty of the lesser-included offense of second-degree murder. Option C, the defendant is guilty of the lesser-included offense of manslaughter. Option D, the defendant is not guilty as to count 1. Any objection or request?
I'll make the same request that I make in all cases. We would request that not guilty be the first option, since she has the presumption of innocence. We would also request that the words guilty and not guilty not be in all caps and bold.
As to replacing the order, I believe the standard instruction not only identifies guilty, not guilty, but the state is the plaintiff in this matter and has brought the action. They are entitled to the first option. That is overruled. As to the options being in bold or not, does the state have a position at which is to raise?
The only thing I would suggest, if we leave them in bold, it makes it clearer for the jury to differentiate between each of the accounts, but I don't have any real strong feelings, but I see why they would be in bold.
So you are requesting for it to remain the same or to not be bold?
I request they remain the same simply because I think it makes it much clearer to the jury to identify what is what. It's not suggesting anything, it's just making sure they recognize which box they're checking.
Very well. It will remain in bold. This is for the purpose of clarity. No other purpose is involved. As to count 2, we, the jury, finds as follows as the count 2 of the indictment: conspiracy to commit murder. Check, only one letter choice as to this count.
Your Honor, what about all caps for the guilty, not guilty words in count 1?
This is stylistic because ultimately this has no bearing on how they're evaluating the evidence, correct?
I think the same reason why I'm asking for the names of the charges to be in regular caps, not all caps, throughout the instructions. It's the same principle.
State, do you have a position?
Your Honor, I think it's, to me, when it comes time to sign the verdict, we want it real clear which boxes they are checking. I think this makes it most clear. That's the reason I think the all caps and the bold are appropriate. The only stylistic change I would suggest, and like count 1, probably need to move the degree murder that's up under it over to fully under B, under subsection B, and manslaughter fully under subsection C, so it's not up under the check box. But other than that, I think throughout the verdict form we're going to be asking the same thing. Leave it as is, because I think it makes it much clearer to the jury when they're looking at it. You know what you're checking.
As to the body of the instructions, I will grant the defense's request for the verdict form itself. Again, the object specifically is to have clarity as to what verdict the jury is reaching and why. The form will remain as it's currently presented. 2 options, guilty and not guilty for count 2. Same 2 options for count 3, guilty and not guilty.
Would suggest, Your Honor, for count 3 that you move it off page 16 to the top of page 17.
I've been making several edits, so my pages aren't the same, but it will flow to where it's not being broken up between pages.
Thank you, sir.
All right, closing argument 2.7. Any objection or request?
No, sir.
No, Your Honor.
How much time is each party anticipating for their closing argument?
2 hours, Your Honor.
We would say the same, Your Honor.
Very well. Both parties will have 2 hours to present their arguments. Ms. Kappelman, yours will be broken up based on what the law permits between your initial closing and any rebuttal that you wish to give to the defense. You'll need to be mindful of the time. I will help you in that regard as well. 2 hours.
Don't tell me too much.
Submitting the case to jury, just with the time, nothing else. Any objection or request?
No, sir.
The items that are going to be sent into the jury room, I believe we have photos, discs, jump drives, written reports. Is there anything that the parties are not asking to go back into the jury room?
Just the demonstratives, Judge, all the exhibits, I think.
A demonstrative is not admitted, so yes, I would agree. It is not to go back into the jury room.
Ms. Dugan and I spoke earlier during the trial about going through especially 73 and 73 and make sure it complies with the court's ruling, so we'll do that before they're sent back.
All right, and I will just leave it then. The photographic discs, jump drives, reports, and document exhibits will be sent to the jury room with you when you begin to deliberate. If you wish to see any other exhibits, please request that in writing. And the final instruction, when we reach the end of the case, instruction upon discharge of the jury. Standard language once again. Any objection or request?
No, sir.
No, Your Honor.
I believe the remaining edits that I need to make within the body of the instructions concern the capitalization and the names. I believe the state has requested within 3.5A for manslaughter. It is not necessary for the state to prove the defendant intended the death of Daniel Markel. I believe the defense is reserving any objection as to that instruction. That will remain for now. Also added to both principles, this instruction does not apply to count 2. The defense was asking for time to review that as well. Or was it specifically as to count 3?
It's specific, principle applies to count 1. There's not disputing that in any way, shape, or form. I wanted the opportunity to look at it as to count 3.
As to the language, this instruction does not apply to count 2 appearing in both principal instructions. Does the defense wish to be heard?
No, Your Honor.
All right, once I've made my edits, I will send through my assistant an updated copy of the instructions. I will also rule on the items that were submitted by the defense prior to the end of its case. And then from there, we will roll into the instructions and the closings tomorrow morning. Please report by 8:30. We will await the jurors. Any issues that can be resolved concerning the exhibits, certainly confer and advise tomorrow. We're in recess.